Now, this bill, I voted no. Okay, again, but you've got a situation where the legislature didn't pass this bill yet, but you're petitioning under an old code, and you know that you've got residents in it. So why are we doing this?
The residents did it, Senator.
Well, Bill, I respectfully have to say that this is not good public policy. Taxation without representation is what the United States is founded on. We've got a situation where you've got residences that are being brought in under an old code which is designed to do commercial property tax owners. It's not designed, because if we let this neighborhood petition, why not petition every neighborhood in the city of Houston? Well, because the drainage tax, 80% of it is going to salaries, not a lot being getting done, so let's get another management district out. I mean, I strongly disagree with this being used for this public, especially after the bill didn't pass in the legislature. I intend to file a bill to stop it. I do not believe that if a management district is looked at in the legislature, it should be bypassed and go by petition to the TCEQ. There's reasons why the elected officials of the state, some of them voted yes, some of them voted no, but not all of us passed the bill. And I really strongly disagree with allowing a backdoor public policy that if a bill fails in the legislature, if a special act to create a district fails, I don't believe there should be a bypass to allow it to be created post facto. That's my point.
Senator, the other side of that, if I may, because you and I agree just about on everything, but the other side of it is there are people who really want these management districts, okay, municipal districts, municipal management districts, and that bill, I'd like to see a history on it.
Sure.
And I also would like to know how we can fix it to address the issue that you have, and I don't blame you, but everyone in this committee voted for it except yourself. I understand you got your, and you just stated your reasons, but I think we can make it better, and that's what the legislative process is all about.
Right.
Is to try to address issues that anyone, especially legislators, who are going to be voting on it, might have an issue with, and then we go from there. I would like to go to the next panel. I think this is excellent.
Okay.
I appreciate everyone on the panel. This has been an exemplary panel in terms of your background and what you've contributed over the years here that I've seen. I know all of you pretty well. And I appreciate the work you do, and we will work together to try to find middle ground at all times. Good. So thank you very much. Have a beautiful day, all of you.
Thank you.
This concludes our invited witnesses for Charge 2. Ladies and gentlemen, the chair now lays out Charge 5, which directs us to review existing statute and rules that govern the Texas Department of Housing and Community Affairs in light of the recent Supreme Court decision in Inclusive Community Projects, Inc. versus TDHCA et al., and recommend if any modifications are necessary to conform to the decision. The chair now calls up panel number 1 for Charge 5, Michael Lytle, Bu Eccles. Or Exles. Okay, that's CL, excuse me. Okay. ECCLES. Bobby Bowling and Janine Cisak. And Mr. Chairman, I'd like for you to take the gavel.
Okay, before you go, look at Senator Campbell.
I'm sorry. Senator Campbell, would you like to be right back?
Yeah, that's right. Gentlemen and ladies, come up to the front. Okay, we're doing charge number 5. Here's the charge so I can read it. There we go, here we go.
It's already been done.
Okay.
We already have the minutes.
Okay, great. Just so we know, the charge number 5 for the audience is review existing statute and rules that govern the Texas Department of Housing and Community Affairs in light of the recent Supreme Court decision, Inclusive Communities Project Incorporated versus TDHCA et al., and recommend any modification necessary to conform with that decision. Let's see, I think we have Michael. Mr. Little, state your name and who you represent.
Thank you, Mr. Chairman. My name is Michael Lytle. I am the Chief of External Affairs for Texas Department of Housing and Community Affairs. Wanted to start off today by just letting you and the committee know that our Executive Director, Tim Irvin, couldn't be with us today. He is actually with his wife. She's having major surgery today, so he apologizes for being out. But we do have a pinch hitter today for Tim, and using the baseball analogy, he's a free agent that we signed from the Attorney General's office last year named Bo Eccles. Bo is our general counsel and was someone who was very involved with this case.
Michael, before we proceed, did that cost us like a player to be named later or something? That's right. Sorry, the Astros aren't doing as well as the Rangers right now, so let's hope we all recover. But go ahead.
This is true. Bo has a very good knowledge of the case, and so I'm going to turn over to him in a minute. But just want to let you all know that if you have any questions regarding the programmatic impact of this case, I'm here to answer those questions if they come up. So I'll ask Bo now to take it over, if that's okay.
Okay, you're on deck, but now you're in the box. Go ahead and take a swing. State your name.
My name is James Bo Eccles. I apologize for my ancestors picking the funkiest spelling of that last name.
Okay.
No player to be named later or anything like that, I can assure you.
Okay.
As I've been trained to do, I want to just cut straight to the answer to this charge, and that is what statutes or rules and modifications to them are necessary to conform to the Supreme Court's decision in ICP versus TDHCA. And the answer is that the Supreme Court and the remanded to court now, the district court, has not yet issued any order that invalidates a statute or rule. So the answer is technically none. Now, I don't want it to appear that there is no weakness, no infirmity, no possible option for anyone to ever sue under the Fair Housing Act. Again, it's just that to specifically answer the charge question, no statute or rule has been invalidated by the Supreme Court or the district court yet.
That's rather fascinating. Well, so you're telling me that the lawsuit was decided upon merits, points of law that don't require, it didn't strike down any existing code, didn't overturn any existing statute. And I'm kind of fascinated by this.
Well, and I will go back and I'll give a brief history of the case, and I'll give you the posture. I just wanted to give you kind of the punchline.
The answer is rather interesting, so please fill in.
Okay. Back in 2008, this lawsuit was filed as an intentional discrimination lawsuit under the Fair Housing Act, essentially saying that TDHCA, by its rules, was placing tax credit developed properties that's using a federal resource, and I'm happy to go into as much detail as you want on that, or just gloss over it. Feel free to ask questions.
At least I think the members of the panel are probably up on the concept of tax credit apartments, but go ahead.
Wonderful. So it was an intentional discrimination lawsuit saying that the developments were placed in predominantly minority concentrated areas in Dallas. The end result was the district court did not find that there was intentional discrimination. In other words, there was not a law or a policy that said that favored placing intentionally discriminating against minority concentrated areas over non-minority concentrated areas, but the court did find that there was non-intentional discrimination or disparate impact, that by operation of a policy there was a disparate placement of properties that favored or disfavored one protected class versus another. That went up on appeal to the Fifth Circuit, and forgive me, again, you can tell me to go back. I'll skip over the Fifth Circuit and go straight to the Supreme Court.
Right, because it obviously didn't matter, but go ahead.
Clear.
Right, yeah, that's right.
Supreme Court finds that indeed, because this was the major question, is there such a thing as a disparate impact claim under the Fair Housing Act? And the Supreme Court found yes, there is. It made a significant analogy to Title VII law, which is employment discrimination, and found that by the reading of the law and history that the Fair Housing Act should also contemplate disparate impact discrimination. And it sent it back to the district court to determine first, has the plaintiff in this case made out what's called a prima facie case of Fair Housing Act discrimination. Prima facie being first look, a threshold matter. The prima facie case is there not just a statistical disparity, but has there been a policy identified? Is there a law identified, a policy, something that says if you do this, it creates a disparate impact? That's the prima facie case. So it's identify a policy and show a robust causal connection between that policy and a disparate impact. That's where we are right now. It's been briefed up by the Attorney General's office and the plaintiff. It was argued in front of Judge Fitzwater in the middle of June, and we are awaiting a ruling. Keep in mind that the ruling by Judge Fitzwater, whether it is they have identified a policy or they haven't, is not going to be a final ruling that says that policy is invalid. There's more to go before anything is finally determined to be right or wrong, unless Judge Fitzwater rules that the plaintiffs have not made a prima facie case, in which case, unless it goes up on appeal, the matter is concluded.
And what was the vote of the Supreme Court on this?
It was 5-4.
5-4, okay. Why don't we go ahead and ask questions of the department that's here. Go ahead, Senator Menendez.
Sure, no problem. So one of the questions that I have, and Mr. Eccles, I'm sorry, how long have you been on the team so far, if we continue with the analogy?
1 year.
A year, good. One of the things I'd like to see is stats that show has the department had the capacity to implement the tax credits that have been sent down from Washington? Have we been able to build out affordable housing in the state to the degree that we were doing prior to the Supreme Court? Because I think the case can be made eventually that if by the decision by my understanding, the decision by the agency has been that after the Supreme Court, even though this case was in North Texas, you applied what they were asking you to do statewide. And you have said now you have to make applications and try to build these in high opportunity areas, is what I think you define them, right? You call them. So what I find odd or interesting to some degree is sometimes where the need is greatest, sometimes for affordable housing, you no longer, that area is no longer the area, because of the Supreme Court's decision, an area that will get extra points and will qualify. And so now you're actually forcing the applicants to go into areas where sometimes they're going to be finding more resistance. And so I think we should have affordable housing as a state. I'd hate for us to turn into California in terms of their affordable housing situation is deplorable. And what I like about Texas, and especially the tax credit program, I have found that some tax assessor collectors can say, we can't tell the difference between an affordable housing project and a Class A project. That's the way it should be.
Exactly.
Because in my opinion, children don't know that they're poor and shouldn't have to know that they're poor. And I think that neighborhoods shouldn't have to be afraid of affordable housing. So my concern is that the actions or the net result, and I'd love to see some data of the Supreme Court's action, is that we're not building as much affordable housing as we could as a state. Bless you. Because some of these most, if not every one of these developments are the kind of developments that a first-year police officer, firefighter, teacher, someone has to have a job. It's not free rent.
That's true.
And you have background checks, criminal background checks. Is this not correct?
That is, yes, that is true.
And you have compliance that you have to meet through the state and through the federal government, correct?
Yes.
So in many ways, these developments are safer and more highly regulated than something the free market puts in. Is that not correct?
I would definitely agree with that, yes.
Much more regulated, and therefore, and because of what the state has done over the past in terms of not allowing developers to take their development fees at closing, not allowing for flipping, the fact that you're deferring, you have maintenance, deferred maintenance and financial feasibility being number one on the scoring criteria. So we're making sure that none of these become eyesores that sometimes people think it's a tax credit development, and it really isn't. And so one of the things I think we need to do is do a very strong analysis of what have been the results, okay? Because I'm all for affordable housing being spread throughout the city, that people not be forced to live in pockets of poverty. I agree with that. I agree with the intention of the Supreme Court, but I don't necessarily agree that it's a good idea to limit it in such a way that we don't allow for as great a capacity for affordable housing to be developed. And so I wish you could help me, and I'm not sure if you came prepared for that today.
I didn't come prepared with that, but I'll also actually throw in a little bit of a twist.
Please.
You've couched this in terms of the results of the Supreme Court decision, but high opportunity areas as a concept was actually introduced in the 2009 QAP. This has been an evolving process before even the district court found initially that a remedial order was necessary. And that's because under the Fair Housing Act, there is an obligation to affirmatively further fair housing. Well, what does that mean? We have our definition that we have developed not specifically of affirmatively furthering fair housing as a state, but there is the policies seen through the government code and the evolving QAP, that is what is affirmatively furthering fair housing. There is the housing and urban development definition of affirmatively furthering fair housing, and their recently promulgated rule to that effect, which is very expansive. And then there is what the Supreme Court has told us through ICP is the limit of what they expect if you're bringing a fair housing lawsuit. So to the extent that what you're asking about how much of the development has been funneled into high opportunity areas, that began a long time ago as a reaction not to the court saying so or the Supreme Court, but this evolving concept of fair housing. Now, I would agree with you, there is you've gone too far. There is the idea that now you're saying you've promoted through the QAP developing only in the ETJ, or so far out, or haven't you're disfavoring building new developments in an area with what's the federal definition of a qualified census tract that has higher levels of poverty, lower levels of income, and for TDHCA standpoint, there's a strong educational excellence component that goes with these decisions of where to locate. So there could be the argument that perhaps the state has gone too far in emphasizing. This is the balance of the QAP, and we're certainly every year working on trying to pull back, making sure that the developments aren't too far flung, aren't abandoning the core, are still trying to balance what is the level of educational excellence, for instance, in an area. Is it fair to go with the statewide average, or shouldn't it be regionalized? All of these things are being considered, and I agree with you, Senator, that we can't just have we've thought about it once and now we don't have to think about it again. It is constantly changing.
Well, I implore that you continue to use common sense, because of the fact that, you mentioned statewide averages versus regionalized. Austin, Texas is a perfect example of the disparity in income and average income here versus, let's say, Texarkana or somewhere else in a rural part of the state. You can't compare the two incomes. And so, in many cases, people are being forced to live in the outer rural parts of Travis County and beyond, just in order to be able to have a job here in the service sector in Austin. So we have to, as a state agency, I think, to some degree, need to help educate us, the elected officials, by saying, look, here is an investment that the federal government is allowing us to make. These tax credits are an investment where we as a state can help improve housing opportunities, and it's not like you're building the Section 8 ghetto towers of the 80s that we know is a failed policy. This is a mixed income in an area, leveraged to some extent to provide some units for affordable housing, but built in such a way that they can withstand market pressure and the market demand for them. And so I think I would like us to bring a more common sense approach, one that every legislator could welcome this, like I did in the sense in one part of my district where the implementation of a tax credit unit got rid of a junkyard, got rid of a graffiti-filled wall. It was the first investment in 20 or 30 years that anybody had made of that kind, and it has spurred more investment in that community. And so I used to joke with a lot of people, that's fine. If you don't want the tax credits, we'll welcome them. I think people just don't understand, and they don't know what they don't understand. So at some point, it would be good for y'all as an agency to have a sort of a what really are tax credit developments. They're not these, sort of like that, to play on that old Buick or Oldsmobile commercial. These aren't your grandfather's tax credits. This is not what it was many, many years ago. Thanks to a lot of the pressure that y'all have been under, and the development community has been under the competitive pressures, these are things that people should not be afraid to welcome into their community. And many who have had them have seen the benefit. I don't want to take advantage of the time, Mr. Chairman. I'm going to...
Thank you, Senator Mendez. Senator Campbell, any comments? Okay. Let's go to the next invited witness. That would be Mr. Bowling. State your name, who you represent.
Hello, Mr. Chairman. Good afternoon, and good afternoon, Senators. My name is Bobby Bowling. I'm a third-generation home builder from El Paso. Currently, I'm serving as the president of the Texas Affiliation of Affordable Housing Providers, or TAAHP. It's mainly our tax credit industry trade group. We just finished our convention, our annual convention 2 weeks ago, and I'm proud to represent that group. Almost probably 90-95% of the tax credit developers in the state of Texas are represented by our organization. As you probably well know, the tax credit program is by and large the program that TDHCA administers that really gets housing built in the state of Texas. For a little more background on myself, I said I'm a third-generation home builder. I'm from El Paso. We build, my brother and I, we have a single-family home building company. We do about 250 homes a year, in addition to about 200 apartment units that we do every year, mostly tax credit. Almost everything we do is affordable. I've been in the program since 1999. I've been fortunate enough to have been awarded 28 deals. We have 2,500 units on the ground that we own and manage in El Paso County. It's a great program. It's a program the federal government actually got right, notwithstanding Senator Lucio's comments this morning about how things in the federal government don't always work. They really did get this one right. It has very little governmental intervention. It has very little government expense and red tape that goes through the ultimate product. It's private dollars, it's private investment, it's private lenders, and it's private developers by and large that make this program work. In most of our projects, our developments, I can speak personally and for the entire industry, there are a lot of social services that are provided. GED classes, English as a second language, credit counseling, and home buyer counseling are some of the things that we offer in our properties. So I just wanted to give you a little background about how strongly I feel and how passionate I am about the tax credit.
That we accept, Mr. Bowling, but do you have any recommendations?
I do.
Right.
I do. So I'm not a lawyer. Okay. I'm a developer. The Supreme Court of the United States, in their ruling, from my understanding, the way I read it, is they upheld portions of the disparate impact. We like, as private developers, the portions of the ruling that talked about kind of explicitly exempting private developers from the disparate impact burden. But it kind of reemphasized, the way I understand it, the burden on governmental entities. So, for example, if there's a disparate impact claim that comes from a development that I did by following the rules of the state of Texas, it's not really the suit against me that is going to be the cause of action. It's going to be the suit against the state of Texas, again, for their rules. So, having said that, and Mr. Eccles mentioned HUD's affirmatively furthering fair housing ruling that the Supreme Court also kind of mentioned in their remand to the local court again. I think that the state of Texas and TDHCA still may have some exposure going forward in this lawsuit, and I want to talk through that with you. So getting specifically to your charge, what can the state do? The state has legislatively mandated certain items. Every state must have what's called a Qualified Allocation Plan, or a QAP. It's part of the federal program. If you want to be eligible for tax credits, you have to have one. Not all states legislatively mandate anything with their QAP. They have a finance agency that's appointed usually by a governor, like our state does, and then they rule make, and they go through a public hearing and they make their own rules. In our state, we have certain items mandated by the legislature, and I think some of those items have become problematic. They were well-intentioned when they were passed, but at this point they're being used kind of as tools for not-in-my-backyard organizations, NIMBY groups, to kind of create maybe some violations of the Fair Housing Act. The three items that I want to speak to specifically that I think are problematic for the state of Texas are the state representative support letters, the city and county resolutions of support, and the neighborhood opposition letters or support letters. Those are three very highly subjective criterion. The rest of your, I believe it's 26 scoring items in the QAP, are all very objective and quantifiable. These three items, however, are a state rep can send in a letter saying I'm opposed to this development. He doesn't even have to explain why. And that's fine, and it's well-intentioned, and I understand local support, and you as a body, the Texas Senate, removed yourself from that process, I believe 3 sessions ago, and that was a very wise move, I think, on your behalf. In one of our panels that we just had at our state convention, there was a phrase that was coined by a representative from cities in the state of Texas, and he said basically what you have with this point item is when you have organized groups of NIMBYs that say we don't want this development here near us because of these children, we don't want them to go to our schools, those people and these kind of things. They're organized voters in many cases, so a city council or a state rep has the dubious distinction of making a decision between, do I want to upset these voters and maybe jeopardize my re-election, or do I want to do what they're asking me to do and maybe jeopardize the city, the state, myself personally in a fair housing lawsuit. So those are the three items that I wanted to speak to you about today. I'm here to answer any questions. I see that my time's up. I don't want to burden you with more, but those are the three items that we see as a development community that there's possible problems and possible liability further for the state of Texas and TDHCA because of the way those tools are being used and because of their subjectivity.
Thank you very much. Questions, members? Thank you.
I was just going to say, on the points, I remember why the points were made the way they were in terms of the letters of support and the neighborhood participation, all in the council. If currently the points are set up to such a degree that it ends up being a veto in a sense, and so it puts the development at risk. I think one way we could fix this, and hopefully the agency could take it upon themselves in order to keep us in the right path with the Supreme Court. Possibly you could just lower the number of points awarded down so where you're not saying that we're completely going to ignore the voice of the people affected in the community. I mean, because I'm not sure if that's going to happen politically, if that will happen. But if you got it to
I can say that it would not happen.
Yeah, well, I think you're probably right. So the point is this. But I think the thing is that if you saw some of the message boards, some of the blog boards that some of these neighborhoods are putting up, and that with the things that they're saying, it has nothing to do with traffic. It has nothing to do with the impact of the development. It is literally, we don't need those people. Our home values are going to come down when they come here, when the crime comes here, when this. All of these things that are really not based in fact. And they're based in fear, and they're based in ignorance of really what's going to happen there. And so I think the concern is that we don't continue to expose ourselves as a state to something unnecessarily. And so my thought is there's probably a happy medium where you don't have to, because we made financial feasibility the #1 thing, because none of us want to award something that's not going to be looking good for 10, 15, 20 years, right? Number one. And make sure that the people that are building it have the capacity to keep it going. So, but if we lowered that possibly, so agency, you're going to be looking at the ability to change that QAP some in order to make this, it's still there, but it's not, it doesn't break the deal.
I just have to mention that under 2306.6710 of the government code, that's what we call the above the line scoring section,
Right.
that which the legislature says
This is what?
has to be part of it. It prioritizes in descending order the
Yeah.
criteria.
Financial
So those
feasibility.
have to be the highest point values.
Right.
And the 10th of those is the level of community support evaluated on the basis of a written statement from the state representative.
Right, that's number 10.
We can't drop that below any of the below-the-line scoring items
Right.
that appear in the QAP that are determined by the governing board of TDHCA.
Bo, would you state your name again and who you represent for that answer?
My apology. This is James Bo Eccles, General Counsel for TDHCA.
And Mr. Brown, do you have another comment? Then I'll
Yeah,
pass it back to the chairman.
I do, Mr. Chair. Again, Bobby Bowling from El Paso. I would like to just add to what Senator Menendez has astutely observed. I believe this is a true statement. I believe in the 2016 round, not a single tax credit development was awarded without the state rep letter of support or the city-county resolution of support. I believe that's a true statement. If not absolutely true, it's the vast majority. So you do have a situation where it's basically a veto now, because the other 9 items ahead of those are things like financial feasibility and things that you wouldn't put forward in your development and go forward and make it to the end anyway. So you're exactly right. The state rep letter is basically a veto letter at this point.
So it comes down to a policy decision that we have to be making here as a legislative body. And I understand the reasons why it's there. I remember having this debate with Senator Ellis about the letter for many, many years. All right. Thank you, Mr. Chairman.
Thank you. Any other questions? Okay. Mr. Bowling, have you testified?
He did.
I have, Senator. If I could add
you
one more
finished?
thing. I
Okay.
have. In relation to this, I came back from a national convention last week, and I found that in talking with my colleagues, Texas is the only state that is doing this, to my knowledge, with state rep letters of support and city-county resolutions of support. Because we were trying to swap stories about litigation and exposure and in light of this Supreme Court lawsuit, and I couldn't find another state that has this in their QAP.
Thank you very much.
Good afternoon. My name is Janine Sisak. I'm also here today representing TAAHP, the Texas Affiliation of Affordable Housing Providers. And like Bobby, I'm also Senior Vice President and General Counsel of DMA Development Company. We are an Austin-based development company that has developed more than 2,000 units of multifamily housing, primarily affordable. You know, Bobby did a good job of providing background of our organization and the challenges that we've faced in recent years with having to get political support letters. You know, one thing just timing-wise is to remember that the state rep letters were put into the legislation before kind of the advent of HOA, of the high opportunity area concepts under the QAP. So this problem has gotten much worse under HOA, and I want to talk a little bit about that because the QAP committee has been working very closely with TDHCA staff the last couple months to look at the definition of high opportunity, which is mostly a census tract analysis based on income, poverty, and to a large degree schools. So what's happened under this definition is there are census tracts that meet all of the criteria that kind of light up on a map. And so what happens is developers, being the competitive type A people that we are, we all kind of flock to these places on the map that score really well. And often they are either in ETJs or they're in rural areas that just happen to be kind of higher income than a larger, you know, less affluent regional area. And so what happens is we all kind of flock there, and we're kind of competing for the same sites, and then cities and I think state reps get a little overwhelmed. You know, why are 5 developers asking me for support for tax credits here? And are we going to be in a position where we're going to have 3 tax credit awards this year? And it's just created this huge problem, and a lot of these areas that score as high opportunity are often, you know, single family neighborhoods that really don't really allow for multifamily or don't have, you know, sites that are suited to multifamily. But there are some sites, kind of that other census tract 3 miles down the road that's kind of on the fringe of town where there's, you know, no neighbors, so you're not going to have some NIMBYism there. So it's created, I think if we look at the analysis of the awards the last couple years, there's a huge gap in the urban areas. There was not a single Austin deal that received funding this year. I think there was 1 San Antonio deal, 1 Houston deal, no Dallas deals, and a couple of Fort Worth deals. So the policies and some of the HOA definitions as they interplay with some of these political support point items that Bobby spoke of is resulting in a program that's becoming anti-urban, which, you know, while I believe in choice and I believe that there should be tax credits, you know, sprinkled throughout the urban areas and the suburban communities, what's happening is it's largely become a suburban and rural program. And you know, I think everybody needs to think really hard about whether that's what the tax credit program needs to look like. You know, we've talked a lot about state rep letters, but I really feel the need to talk about city resolutions as being as problematic, if not more. Unfortunately, as Senator Menendez pointed out, there are some communities that really want housing and are happy to give unqualified support, don't meet the HOA definition. So that's a non-starter for many communities, which is a huge problem. Another problem is, you know, in one case that I personally encountered, I had a site in a city in a high opportunity area that was zoned multifamily, and I couldn't get the city to even make a resolution. It died for lack of motion. So these are kind of some of the things we're encountering. There's way too many opportunities for these deals to be vetoed. It's not just state rep letters. It's also on the city level and by the sophisticated neighborhood organizations. Those are my comments.
Senator Van Gordon.
Thank you, Chairman. Ms. Cizik, is it?
Cizik.
Cizik. I thought there were 3 projects approved in Harris County last year.
That's possible. I was talking about the 2016 awards.
The 2016, okay. I'm just trying to understand. And were you up to date on the City of Houston issue recently? A project that was that the mayor effectively canceled for lack of better, so that was Mayor Turner.
Right. I've heard about that development.
Okay. And so I guess if you have that opinion, do you have a substitute for community involvement? Because clearly it's on the list. So I'm kind of fascinated by this. If there's, do you have an idea for it, Ms. Cizik, or?
Well, I mean, I think there are a couple of solutions. One is looking at the points, you know, reducing the points so it wouldn't be an all-on veto. I think city support's now 17 points. State rep is 8 or -8, so it's really 16 points. And I think we need to kind of look at that to make sure we're putting that right in the point priority. Isn't it? I think it's being treated like an 8-point category, but isn't it really a 16-point category if it's a swing? So we can look at that. We can also look at an either-or scenario. I think at one point that was discussed. It was either state rep support or city support. So I think that there are some options there. Another option is maybe city support. You get automatic points for city support if your site is zoned multifamily and you're not requesting any variances. So things like that I think could really kind of soften the blow and take the, you know, you want to keep it as a tool for cities to show support. You want to take it away as a tool for cities to violate fair housing or NIMBY for just, they don't want tax credits. But if it were if it were market rate, that would be fine. It's just, when it's, I forget the legal term, when really the issue is that they don't want low-income housing in their community, redlining or...
Thank you, Mr. Sack.
If I could add to Senator Betancourt's question. To just take you back a little bit, Senator Betancourt, I know Senator Menendez was in the House working when this happened, but we used to not legislatively mandate anything for the QAP as far as a hierarchy of points. This came in a time where TDHCA, under different management and a different board of directors, had been undergoing some scrutiny and some legal issues and some favoritism accusations. So the legislature actually stepped in and said, we need to watch you more closely. I think that the agency, that this has been like 13 or 14 years ago that this happened, and I think that it's come a long way, and I don't think there's any of those concerns at the agency anymore as far as ethical concerns. And my answer to your question directly would be remove these items and lessen the burden to the agency from the legislature of what you shall do.
Okay, well, and I guess I just want to point out that not only did Senator Menendez serve in the House, but also Mayor Turner served in the House. Mm-hmm. And clearly his position was substantially different on this last project. So it would kind of be fascinating to hear what he believes on the subject at this point.
I think part of the Mr. Chairman, if I may, part of the problem is in some of our communities like Harris County, Houston in particular, without zoning, the community doesn't have an opportunity to sort of lay out what's the highest and best use, and having buffer zones between residential, commercial, and so you have harmful situations, I think, to good, thoughtful development. At the end of the day, in order for the things that you're saying, for them to move forward, quite honestly, I believe that there's going to have to be an education process. That it's going to be very, I was sitting here thinking, okay, so what does affordable mean? And how many units? Because, my good colleague, Vice Chairman Betancourt, brought up 3 deals in Harris County. Harris County is what, approximately 8 million people?
4 million.
Okay, 4 million. The whole county? 4?
Yeah, 4 million.
So, I don't know why it seems so much bigger when I'm there, but
well, it's 1,000 square miles of flat. Yes, it goes on.
So 4 million people. Every one of those developments is a max of 252 units. Is that correct?
That's about right, Senator, to make it work feasible.
Okay. Yeah. Typically, they're about 250 units. So you're talking about 750 units approximately and not every one of those units is affordable, just to the extent that they're looking to get a tax credit. So that's the thing. These are mixed income, and that's where in urban communities, where let's say you have a downtown setting, where you're trying to squeeze something in, where some folks in the service industry can be working and living close to their place of work, side by side with maybe urban professionals, and maybe potentially put a grocery store in the first floor and then have residential above it. This is a tool that we have that can work, and the only reason it works, and you heard it from Mr. Bowling earlier, is because what it does, it allows for some credits to be sold. So where we're at the government level, we're not doing anything but making sure that they do set aside the units that they say they're going to set aside for affordable. Other than that, the private sector takes on the risk, the development, the whole thing.
Well, Senator Menendez, that's why I was kind of interested in the panel, in the next panel of 5 that we're about to call up. I was kind of fascinated to see, okay, here's the Supreme Court ruling, and then we've had our first major known urban area discussion post this ruling, and the city of Houston pulls out on it immediately. So, I'm kind of fascinated by literally the dichotomy here. So,
we need a lot more educated response, I believe, is my thought to the whole thing. Thank you.
Thank you, and thank you for your testimony. Who's next? Everybody done? Done? Okay, thank you very much.
Thank you.
Panel.
Thank you.
Sorry I missed you, Michael. But,
I have
I
written
will see you
testimony.
later. Yes, sir.
Mr. Chair.
All right, we go to panel 2 for charge 5. Neil Ratcliffe, Mike Surgru. Okay, Surgru. I'm sorry. And Paul Farmer.
Just three.
Welcome, gentlemen, and as we'll take them in the order I called you up, Neil, Mike, and then Paul. For the record, state your name and who you represent, please.
Good afternoon, Mr. Chair and members of the committee. My name is Neil Ratcliffe. I am an attorney with Locke Lord. I am speaking today on behalf of the Texas Affiliation of Affordable Housing Providers and the Texas Apartment Association. I will note that I've testified before similar committees not long ago in my prior employment. Up until about a month ago, I was the director of the Housing and Community Development Department for the City of Houston for about 5 years. So I'm pretty familiar with some of the issues that we've talked about today, but of course I'm not here representing the City of Houston. The charge asks us to look at some of the legislative and rule issues that may arise in light of the ICP case. So I wanted to start with just a couple of statements from the case. Justice Kennedy, writing for the majority, framed the issue of the ICP case as follows. He said, "The underlying dispute in this case concerns where housing for low-income persons should be constructed in Dallas, Texas. That is, whether the housing should be built in the inner city or in the suburbs." The court went on to recognize that disparate impact claims are consistent with the Fair Housing Act's central purpose. And Justice Kennedy pointed out that part of the objective was to eradicate discriminatory practices within a sector of our nation's economy. And he cited that the policy of the United States is to provide within constitutional limitations for fair housing throughout the United States. And cited other legislation stating that we have a clear national policy against discrimination in housing. He then went on to talk about unlawful practices that would violate the Fair Housing Act, and he said they include zoning laws and, quote, other housing restrictions that function unfairly to exclude minorities from certain neighborhoods without any sufficient justification. And what we're looking at now is a massive struggle between where these affordable units will be. Will they be in the suburbs predominantly? Will they be in inner city areas? Will there be a combination of both? I believe that there should be a blending and a combination. I think that we need good quality housing in communities where people live who maybe aren't willing to move to the suburbs or high opportunity areas, and we need good quality housing for folks who desire to make that move. He talked about also how the availability of disparate impact liability has actually at times allowed developers to, quote, vindicate the Fair Housing Act's objectives and to protect their property rights by, quote, stopping municipalities from enforcing arbitrary and in practice discriminatory ordinances barring the construction of certain types of housing units. So when we talk about all the not in my backyard sentiment that we encounter when we go to develop affordable housing, and the plain reality is that in neighborhoods of higher opportunity there is more organized opposition, and I have been on both the public and the private side of affordable housing for the last 20 years, and I personally had the blessing of standing before angry mobs of 300 to 800 people who want to kill me because we're suggesting that we should provide some good quality affordable housing for lower income people who need it in their neighborhood. So the system in place that Bobby talked about earlier, which allows so much concentration of power in the point system through the state rep letter, the city-county resolutions, and also the neighborhood letters, it does effectively allow a veto power. The tax credit program is so competitive that 2 to 3 points can determine whether or not you get an allocation of credits. So when you look at the city resolutions, those can provide 17 points for a resolution of support or 14 points for a resolution of no objective. That is a gargantuan quantum of points within this system. The neighborhood organizations can provide between 9 to 4 points, and as was mentioned earlier, the state rep letters can be 8 points plus or minus, which is really a 16-point swing. So that makes it pretty tough. If you have a situation where where folks are trying to kill a project for reasons that are the very kinds of veiled discriminatory purposes that the ICP case was trying to avoid and the Fair Housing Act is trying to avoid, and which the Department of Housing and Urban Development in their recent regulations have worked very hard to try to avoid, then in my mind, we're kind of on these legislative policies giving so much weight to those three factors is kind of on a collision course with where the court is going in the ICP case and where HUD is going. If I may take just another moment, please, sir. I would also express the fact that while well-intentioned, the city resolutions, for example, are really difficult for the cities to deal with. The timing process, from the time that a city realizes who is on the list to potentially get credits, which that list came out on January 25th, I believe, last year, in the last cycle, we only had until March 1st to figure out, and 19 letters or requests for resolutions of support came to the City of Houston. That is a lot. And so we had city staff trying to figure out, are these applications good? What are these developers, the best folks that we think that we should support? And we had very little, if any, information to go on. All we had was in the pre-applications. And by March 1st, the resolutions had to be submitted to the Texas Department of Housing and Community Affairs. Now, in a city like the City of Houston, with an agenda process where it takes us 3 weeks at minimum to get something even on the council agenda, we were sandwiched into such a, I don't know if it's raining or snowing or what, or somebody snoring perhaps. But pardon me, the time frame was so truncated as to make the process really not meaningful. And frankly, it was incredibly burdensome. And it did tend to just alarm neighborhoods when suddenly there's 19 applications that they're freaking out about, right? When in reality, only one of those applications ever actually received credits. So I think, while well-intentioned, the city resolution requirement was very burdensome. Not only did we have to try to figure out what neighborhood groups would support those projects or didn't, so did the district council members. And the district council members were not happy with the fact that they had about a week to figure this out, right? And to be able to make decisions regarding whether they were going to support these resolutions or not. And to complicate matters, if an application was in the extraterritorial jurisdiction of a city like Houston, you had to also visit with the county commissioners. So within a couple-week process, we had to try to vet community support, go through 19 complex applications, and coordinate between city council members and county commissioners regarding what we should or shouldn't do on a massive number of applications. And so I would suggest that while well-intentioned, the process practically wound up being so difficult to work through that it was effectively a huge waste of time in many respects and resources, and not an efficient use of taxpayer dollars, in my opinion. Finally, I'll just say that putting our elected officials in that rock and a hard place between being concerned about having fair housing lawsuits hitting them on one side and perhaps not getting elected because some of their constituents may feel that while housing that is affordable and quality is needed somewhere, they don't want it in their backyard, and they frequently come up with reasons that aren't racially motivated on the face, but seem to be exactly the kind of racially motivated subterfuge and animus that this court is trying to protect against. So I don't, when some of these rules were put into place, they may have made more sense, but given the evolution of the law, it seems to me that, we're driving down the freeway on the wrong side of the road, heading for a head-on collision, and we ought to be prudent and get back over on our side of the road and and pull ourselves out of this precarious position, which the Senate, as was mentioned earlier, I think was wise enough to do a couple sessions ago. Thank you.
I'm amazed, so only two of us are left right now at this point, but they will be coming back. But it just so happens that Senator Menendez and I have been working on housing issues for a number of years.
Just a few.
I remember starting in '87 and coming over here, and then obviously teaming up with Representative then Menendez, and I can say this: certainly we want to find the right answers to address the need in housing in Texas. There's quite a bit of housing needs, as I've seen myself with my own eyes. I have a 23-city tour later on this year, and that's one of the issues that I'll be looking at very carefully and seriously, because obviously housing is the base. It's a home base for families and individuals who want to start out in the home. Senator,
Real quick, Mr. Chairman, you know what it is? I think it's maybe this mic right here. It's messed up. But anyhow, Mr. Chairman, one of the things I want to ask everyone that participates in this, because you're in the trenches, I heard recently of a deal in the Harris County area, I think your firm may have been involved, where you had a letter of support from the state rep, and then all of a sudden there was some animosity towards the application, and now he wanted to revoke his letter and issue a letter against it after he had initially supported the issue. One of the things I'd like to see us do is if y'all would help us up here collect the data, the information, the comments, the reason, the rationale, so that we can sort of sift through what is genuine and what is sort of imagined perception of concern, of worry, whatever. Obviously, you heard earlier from one of our colleagues that, it is his belief that this is not going to go away. So the question is, it may not go away for a lack of political will, because there's a lack of, or there's a concern that we would not be heeding our constituents' concerns, but it may need to go away because the Supreme Court sees this as something that we're allowing communities to create a disparate impact on people, and that's what it seems that's happening. And what's frustrating to me is that, Mr. Chairman, so many times when I've been in these meetings, I'll ask some of the folks that are upset, they go, well, what does your child do? Well, they just got out of college. They just started their first job. Well, you know that they qualify to live in this location right here. So many times people don't realize that they could have a net benefit from having new quality affordable housing in their community. So we've got to do a better job, but I think it's going to be a collective effort on behalf of y'all in the community, on behalf of the agency and all of us, because unfortunately we're dealing with the hangover of some people not behaving well in this whole process. And that's why we ended up having to do some of these letters, to have sort of a watchdog approach. And so these things, like many things, when there's an overcorrection, when you allow politicians to get engaged, that's what happens. And so I think we need your help to undo it. So my phone's trying to get me to do something. Anyhow, thank you, Mr. Chairman.
Well, and if I may add, the Supreme Court has recognized in numerous cases that it's important for the law to protect minority groups from the actions of the majority, which may be unjust or unfair or just plain wrong. And so when we have a system where there's so many elements involved to make it objective and clear and fair, and then we throw in a few elements that makes it hyper-political, it seems to me to kind of, in today's context, legally, make no sense to put so much weight on the political component of this process versus the objective and the measurable and the reasonable
I wholeheartedly
pieces.
agree. I really do. At this point, I just don't like the system the way it's developed. I think there must be a better way of doing things. So that's my personal feeling right now. Let's work at it between now and the end of the year, see what we can do to come up with some solution. Senator Menendez, any other thing? Thank you very much. State your name and who you represent for the record, please.
Good afternoon, Mr. Chair and committee members. My name is Mike Shagrew. I'm the president of Stone Leaf Companies, and I'm here representing also the Multifamily Council chairperson of Texas Association of Builders. I'm a member and a past president of TAAHP as well. As a member of TAB, I'm a member there because of its dedication to the housing affordability. TAB represents over 10,000 members involved in the building, remodeling, and development of single-family and multifamily housing. Is it this one? Is it me? I thought you said it was you.
It's our technical person around here.
All right, so anyhow, to get back on point, our industry represents 702,500 jobs and $31.1 billion with the B dollars of revenue in the state of Texas. TAB supports a balanced approach to fair housing that allows builders to develop quality and affordable housing for all Texans in all areas of Texas wherever housing is needed. I want to emphasize where housing is needed. I'll touch on that later. I appreciate the opportunity of being here today and to talk about the impact of the ICP case on the QAP, et cetera, and what we think may be done. I've been doing this for a little over 40 years. I actually got involved in this in the Tax Reform Act of 1986. I was 12. But as an on-the-ground builder focusing solely on affordable housing, the QAP rules are what we have to use on every project. Senator Menendez made a couple comments earlier that I want to applaud. One, he talked about for comparable rent, we provide safer housing due to the background checks, etc. And I will add to that, we provide a much higher quality at a comparable rent. Our product, knock on wood, is virtually indistinguishable from a market rate product. I believe overall the industry does a great job. There's a growing need to provide housing for our aging population. I'm working on 2 properties right now. Both are senior oriented. Bobby talked about the social services, also not available in a comparable property at comparable rents. We provide more services and a better quality. In the next 20 years, some interesting facts, the population of 50 and above will double in the United States. By 2030, 1 in 5 people in the U.S. will be over 65. I'm way ahead of that. Only a portion of eligible citizens actually receive housing assistance due to the current low-income housing supply for seniors. The gap's going to continue to grow. Many will be left behind to find safe, affordable housing in the private market, which pretty much doesn't exist. While the agency is doing its best to comply with the ICP case, updates to the QAP have caused some unintended consequences that puts limits on affordable housing. I want to applaud the agency for recently having a market analyst roundtable to help with the differences in defining primary market areas, and I'm going to talk a lot about the difference between urban and rural. The ICP case, school scoring was added as a result of the ICP case. While we understand the requirement in a family property, and in general, the better schools are in the better communities. But it should not be a factor in approving a senior citizen property. However, there should be other ways to score those points. Senior housing needs to be where seniors need it, not necessarily where the schools are. They don't use the schools, but we have to find a way to level that playing field so that there's still quality housing. With growing need for senior citizen housing, we should be aware of how restrictions are preventing us from building in accordance with population needs. The urban and rural requirements in the QAP are very similar. The biggest issue that we have right now, I believe, are specifically referring to distances to amenities, a grocery, a pharmacy, child care, or a senior center. I live in rural Texas myself, and it's more than 5 miles to the closest grocery for me. People in rural are used to driving a little further. I like the idea of being as close as possible, but it does happen. We don't want to put undue burden on our residents, but everybody can't live next door to the grocery. We don't want to limit the agency, but we want to make the committee aware of the hurdles that affordable housing builders face as a result of changes to the QAP after ICP. We know that TDHCA is taking steps to remove some roadblocks, like removing the lowest poverty rate. This past year, with the #1 tiebreaker, which actually was where we had to go, and you heard the previous panel talk about 5 people winding up in the same town looking at the same piece of dirt, and that piece of dirt escalating in price. That price is not beneficial to affordable housing, but it was because of the way the scoring criteria was done. The agency has acknowledged some of that, and they're coming off of that. I'm almost done. Like all of TAAHP's affordable housing builders, we rely on a low-income housing program to provide quality, affordable housing. I emphasize quality because Texans deserve high-quality homes that match or exceed the look and feel of a market-rate apartment home. They deserve to live where their families are and where their jobs are, where the community is. That isn't always in the high-opportunity areas, and we should not abandon the existing communities in an effort to satisfy the requirements of the ICP case. We are required by law to fulfill the HUD rule in affirmatively furthering fair housing. To quote it, transforming concentrated areas of poverty into areas of opportunity. That is exactly what affordable housing developments do. Senator Menendez referred to that, where a junkyard with new property was the starting point to improve an entire community. We positively impact any community where development is located, both economically and social. We create jobs, increase local and state tax revenues, provide amenities that increase the quality of life for residents, and add value to the entire community. Thank you for allowing me to be here.
To turn in your prepared remarks so we can get a copy to each member, please. Okay.
Certainly will.
Any questions, members?
Mr. Chairman, the only thing I'd like to focus, hyper-focus on is the one thing that was said, and Senator Campbell and I were discussing it. It makes no sense that by taking the Supreme Court decision, this high opportunity area situation, that we're going to be asking some people, or telling them, you're going to have to move if you want to live in an affordable place to this high opportunity neighborhood, where they may say, but I've been going to church here for 20 years or 30 years and my kids live around the corner. Why do I have to leave? And I understand. The thing is that what created this situation in the first place was that we used to award so many points for the qualified census tracts. So you said, look, if you went into these poorer neighborhoods, you get more points. So that created it. They just went there. So if we remove both the QAP, the qualified, and the high opportunity, then they'll go where the market requires it, where the need is for these things, and we won't be hyper managing. I think the issue is Texas needs more affordable housing. I mean, we're growing at 500,000 people a year. How many units are we putting on the ground of affordable housing every year? Does anybody know? Yeah, we'll ask the agency that.
What did you say, Michael? 12,000.
12,000 units a year of affordable housing, and we're growing at 500,000 people a year. That's people coming into the state. That says nothing about the people who are graduating from college and looking for an affordable place to live.
The gap is getting wider.
Of course it's getting wider. Thank you, Mr. Chairman.
Thank you. Thank you, Mr. Segru. I got it. And we'll now go to Mr. Farmer.
Thank you, Mr. Chairman. My name is Paul Farmer. I represent the Rural Rental Housing Association of Texas. We represent the vast majority of USDA 515 properties throughout the state, many of which have a tax credit layer. Tax credits have become the only form of funding for these properties, so we're very interested in this. My previous two colleagues here have said pretty much all I want to say. I just want to, from a completely rural standpoint, we have a hard time seeing how a rural designed and created out of Dallas, Texas fits communities the size of Cedar Park, communities the size of Burnett, Texas, communities the size of Ed Couch or Zapata. It is becoming increasingly difficult for us to apply the funds that we need in these small towns. Most of these small towns, when I say small towns, some are 3,000, some are 2,000, some are a few hundred. most of these small towns fit within a census tract of their own. There are no quote, high opportunity areas within this census tract. Well, we want you to construct next to the nice school in town, the higher scoring school in town. Well, there's only one school in town. So to take these rules that, again, were meant for large towns and apply them to small rural towns, which are unique in nature, and I don't think that's best. And to answer a question that Senator Menendez asked earlier, are all the funds being used? On our side in rural Texas, the answer is yes. Of the small amount of funds that we have, which we would like more, but that's a different story for a different day, are all those funds being used? Yes. Are they being used as efficiently as they can? No. I know within our small group, we will certainly take each year. We decide we're going to submit applications for 5 or 6 properties, and we will take the 5 or 6 that need this money the most, that serve the greatest need, that have had the longest time since they've been rehabbed. These are working projects that Texans live in. We will take that list of 6, and then we'll take the list that somebody else compiles that it's going to score the best, get the most points based on high opportunity, low poverty, good schools. Rarely do those lists match. So we have a problem with not spending federal funds and state funds as efficiently as we should and as efficiently as we can. So I would also like to add, I certainly was not charged to come here and speak on the local political subdivisions that provide support, but we will add as a group that is certainly a problem that we have as well. We feel that is very cumbersome. Certainly it is important. I don't think the importance that it currently carries should be maintained. Thank you.
Be interested to see how many more units, how much more housing we could build if we were spending funds that are available, in a better way. If we're not being efficient, it would be that would be the question I would pose. Where could we get to addressing the issue on affordable housing and the need in affordable housing? If we did, and how much could we realize in terms of funds that would be available if we were efficient? Make sense? Is it, or is it just whatever we? In other words, are we being prudent with the funds that are available?
We are certainly using the funds that are available to rehab properties that need to be rehabbed. And I'll a quick tangent here. I also think there should be a distinction between new construction and properties that currently exist. I guess my fear is if we're not prudent with these funds, there will be properties, we certainly own some right now, that will never be rehabbed. They will never meet the criteria that the state has set forward right now. So,
I'd like to expand on that as we go along. Any other questions, members? Thank you. Very, very kind.
May I make one more observation, please, sir?
Go right ahead.
And I'm grateful some of our Harris County and City of Houston senators are here. I introduced myself earlier, Neil Ratcliffe with Locke Lord, representing the Texas Affiliation of Affordable Housing Providers, but up until about a month ago, I've spent the previous 5 years as the Director of Housing and Community Development for the City of Houston. And I will say, I think that the TDHCA as an agency is doing a great job in trying to figure out within the legislative constructs or framework that they're placed to be equitable and to follow the direction that the court is asking us to go in the ICP case. But I do think that modification legislatively is needed to depoliticize the process. And I will, if you'll indulge me just one moment, my wife and I lived in Houston for 24 years, and we just moved to Austin about a month ago. got involved with my local church with the youth group, and I met a young man named Julio Garcia. This young man lives in public housing. He's 13 years old, and both of his parents have mental and emotional challenges. They're not able to give him the support you would hope. He has a 6-year-old brother, and I found out from talking to Julio, he gets up at 4 o'clock in the morning so that he can get himself ready for school, and then he gets his little brother up and gets him ready for school, and then he takes a Capital Metro bus to get to school by like 7:15 in the morning. So while we're talking about Supreme Court precedents and complex rules and bureaucratic issues, I know that you won't, and we will not, I hope, ever lose sight of the fact that these decisions are affecting real children, real people's lives. And so, just as Justice Kennedy said that the central question of the ICP case is where will affordable housing be located, in suburbs or within inner city areas? We need to ask ourselves, what's the best place for Julio to be? Should he be in a rough neighborhood where without much parental guidance he's going to be subject to some tough influences? Or should he have the same kind of opportunities that other young people do out in the suburbs? And the TDHCA is trying to move credits into suburban areas, and a lot of the development community is trying to follow suit. But then we get hammered with not in my backyard opposition that is often just blatantly, well, maybe not blatantly, but racist, bubbling under the surface, and class warfare, and it's just, it's a very, very untenable position for us to continue to put our legislators in, I believe, and the developers and the agency. So
thank you, Neil. Thank you for sharing that story. I'd say it hits at the heart. A lot of children I've seen as well become little adults and take on responsibilities that are not common, for children their age. But they grow up to be incredible contributors to society based on what they have gone through, and their stories obviously are extremely important. And thank you for sharing it publicly. I think it's I too am very saddened when people start knocking down government housing. I'm one of 10 kids that lived in government housing. And my dad didn't want to do that, but that's all that was available. For a year and a half, we're pretty safe when storms hit Brownsville, Texas. But those things sometimes happen, and you think back and you say how grateful. City put a little plaque on there that Senator Eddie Lucia lived here. It wasn't for any other reason that I accepted that, just to show those little kids in that neighborhood that they could be a state senator or a governor as well.
There you go. That's wonderful.
It takes, in Spanish it's called ganas, G-A-N-A-S.
Okay.
I'm glad this group
Understands
knows what ganas is.
Well, okay, that means Senator Garcia and I are going to get together and do a plaque for Julio, isn't it?
Well, I tell you what, I
do
want
it
to
in
be there.
advance.
I want to be there to help you put it out, because I think that's an incredible, wonderful story, of human spirit. And they take not only Julio takes responsibility in taking care of his younger brother,
Right.
Yes,
but
sir,
also
6-year-old.
mother and daddy.
Yeah.
That's remarkable, and I just, this story makes my day today. Just, it's wonderful to know that there are kids like that in this state that we can look at, and other kids can look at as role models, for themselves in the future, that we feel is in proper order, knowing that there's children like this that are going through rough times. A lot of them dreamers who want to become, a contributing citizen of this community through education.
Right.
And they will certainly fight hard to make sure that those that are less fortunate have an opportunity as well to succeed. So thank you very much. Any other questions?
Very welcome.
Thank you. All right, well, our last panel